I've hit recording on mine again, Beth, so we can splice the two together, right, if we want to have the bit like this. Okay, so let's get going, everybody. Welcome to workshop 2. So I'm going to share my screen now. Well, we are going to be getting to grips with your most important legal document, your own personal superhero. Thank you for everybody for joining in the fun and sharing your favourite superhero in the Facebook group. And as I said, all of your interactions in the Facebook group, I am loving it. It's great to start to really get to know you all. That's one of the funnest things about this. Remember, really honour this investment you've made in yourself. Turn off your phones and your emails and your notifications as much as you can. Use the workbook. Now, if anyone here who wasn't here last night, let me know. Say hi in the chat. Just say me in the chat. I'm sure Bev will share the link to the workbook again. Don't panic if you weren't here last night. We're going to quickly recap on what we looked at, and there's just one exercise I'll get you to do just while we're getting going in this workshop, so do not worry. This workshop will stand alone. You don't need to have been here last night to understand tonight, so don't worry, that's absolutely fine, but just make sure you've got your workbook to hand because we're going to be going through that this evening. Note down your questions. Now, there will be an opportunity for you to ask your questions today. At the end of this session, there will be a Q&A. I am going to try and keep the main kind of teaching element of this session and going through the workbook. I'm going to try and keep it to the allotted hour. So I'm aiming to finish at 8 o'clock. We are covering a lot of stuff. So the Q&A will be at the end after that kind of main body of stuff I want to cover. If you need to go at 8 o'clock, don't worry because you can catch up on the recording. So the Q&A section will be there for you to catch up with tomorrow. So do not worry, and don't forget we've got a dedicated Q&A session tomorrow as well. Tomorrow's Wednesday. Yes, tomorrow. Open your mind and get excited because this is a great session. It's going to make all the difference to you. I always have to give this little disclaimer. This is not legal advice. I'm not your solicitor. I can't be in this situation. However, I am a creative person who accidentally became a corporate and commercial solicitor over 25 years ago. And I spent all of that time advising businesses on their essential legal protection and 10 years dedicated to businesses just like yours. So you are in really good hands with me during the course of this week. And I am going to be sharing all of the golden nuggets of that experience and those skills I've gained over that time with you during the course of this week. We have got 2 competitions on the go, and I'm going to be telling you how to enter those at the end of the session, but the details are also in the hub as well. I can see that you're all getting stuck in and sharing your takeaways and your ahas, and you can continue to do that during the week. We've got a competition just for engagement in the Facebook group, and that prize, it has nothing to do with legal stuff. It's a certificate, it's a gift certificate, kind of voucher. And we've got a competition where your prize will be a place on our legal lifesaver sprint and a contract review by me. So I'll give you details at the end of how you can enter that. And if you stay to the end, if you're here live and you stay to the end, then there is a legal bonus for you all this evening, which is our legal lifesaver disclaimers. They're just little disclaimers to keep in your back pocket to get out whenever you're feeling a little bit vulnerable. So you're going to find those really useful. So in the last workshop, we were shining a light on where you are right now with your legals and how that makes us feel and how it might be showing up in our businesses and how it might be holding us back. And one of the things I talked about was when I started to collect stories from my clients about how they felt before they got their legal protection in place, compared to how they felt after they got their essential legal protection in place, how amazed I was that the answers really went kind of deep and to the core of their business, the fundamentals of their business, and how they showed up every day. And so we talked about that. So anyone who wasn't here yesterday, The one thing that I'm going to recommend that you quickly do now, as we're just settling into the session, is to go to the workbook and go to page 7. Okay, so just answer those questions, and we've already put kind of tick boxes there to the most common answers that come up all of the time. So have a think about where you are right now with your legal documents, and the next question is the really important one. How does that make you feel? And I just want you to take a minute or two to really feel into that. And we did this exercise yesterday, and people shared some brilliant insights, and there were some real aha moments that people have been sharing on their kind of their biggest takeaways from yesterday's workshop. So just feel into how that makes you feel. How might that be showing up in your business? What kind of fears does it bring about? And we're shining a light on those things so that we can then use that information to kind of get us really motivated to move forward and work out what we need to do to change that. And what I would say is, don't be worried if those questions brought up fears yesterday and you realize, oh my God, I'm really holding myself back because of this. Oh my goodness, I've got some fear around this, or some anxiety around this, or just overwhelm or uncertainty. All of these are really great things because you can sort this out. This is not something that is terribly difficult to sort out or even needs to take a huge amount of time. It's not like if you didn't have the skills that you've all got amazing skills, or you're in the process of acquiring that skills and training in those skills. You've already got that sorted. That's the really hard bit. Getting your legal sorted, that's fine. We can get that done. And by signing up to this event and being here or catching up with this session, you are on the road to getting that sorted. So this is really good news. So anybody who wasn't here yesterday, that's the one thing that I would recommend that you do right now at the start of this session before we get stuck in with all the good stuff. And so this is the page, and this is the section in particular. And these are the things that really come up all the time. I only offer services to friends and family. I don't charge properly for my services. I don't feel professional. I'm putting off getting started or moving forward. I'm nervous about client expectations. I'm worried about refund requests or getting sued. I'm worried about not getting paid. And kind of also tacked onto that is all the kind of area around refunds, cancellation requests, unreasonable client expectations. We talked about that as well. And these are some of the things that you generously shared yesterday in the chat. So Lily said, it feels like a bit of a pit in my stomach and a little bit in my throat chakra. I know this stops me from confidently sharing my more expensive packages. Helen said, legal stuff scares me. I want to make sure I get it right, but I need support. Helen said, I have documents in place, but in the back of my mind, I doubt they're correct and would actually support me if I needed them to. And Sammy said, I'm literally just starting out. I don't have a clue where I'm at or which way is up. So this is all very daunting. And I was totally petrified and feeling very out of my depth. Hopefully that's, luckily, and I'm pleased to see that that's in the past tense, because we started to really get on top of that and started to sort that out yesterday. And we're going to take really big steps forward today in this session as well. Because a good client contract will sort out all of this. Now, I did say yesterday, it's not a magic wand. It can't make all of this completely disappear, not all of it, but some of those worries. A good client contract that is legally correct and that you know is legally correct, and that's a really important condition attached to that, will make a lot of those things go away completely. And for anything that it can't make go away completely, it will manage those things in a responsible way so that it completely changes the energy that you show up with to have those difficult conversations when those issues arise. So it just completely changes your energy and your confidence in relation to these things, so that you are able to be sovereign, to stand firm, to know where you stand. And from there, you can make decisions about whether you're going to really stick to your guns, or whether it's a situation where you feel that it's appropriate to be more lenient. But you're starting off from a very different position to that situation where you're thinking, oh my God, I don't really know. I don't know whether this is right. I just cobbled together the contract. I don't know if it's going to stand up, so I don't feel like I can be confident around this. It completely changes it. And this is some of the things that you shared after yesterday's session. It's so great to see you moving forward already. Today's session made me realize that having solid, legally binding contracts in place allows me to provide my services confidently. That was Gail. Sally said, that was a really great session. Thank you. It's made it feel a little less scary and given me a push to keep moving forward. Is that sorry? I think that's an S. My aha moment was clarifying my biggest worry and knowing where I am right now and having an action list. I'm already feeling empowered and reassured. So what we're going to be looking at in this workshop, we're looking at your most important legal document for your business, which is your client contract. We're going to be thinking about why it's important, particularly right now. When I say right now, in this economic climate and with the particular issues that we've all been going through for the last couple of years, and how it feels selling our services right now, we're going to work out what type of contract you need for each of your products and services. And we're going to be looking at some of the elements that you need in your contract to protect your business, manage expectations, and get paid. If you've got questions, then please put them in the Q&A thread. Now, today's session is all about your client contracts. So can you keep your questions for today for that subject? So any questions around your client contract, your terms and conditions, put them in the Q&A thread. I recommend that you wait until the end of the session to put them in the Q&A thread, because we might well cover off what you're thinking about. So there's no need, you might not need to ask a question, if you see what I mean. So wait as long as you can. Now, if you have to leave at any point and I haven't answered a question you've got, then by all means do put it in the Q&A thread before you go. Preferably don't put it in the chat, because we have a lot of interaction and a lot of chat going on, which means your question can get lost. So it helps me to answer them as efficiently as possible if you put them in the Q&A box as a special Q&A thread here in the menu. The other thing to mention before we move on is, for our Q&A session tomorrow, we ask you to submit your questions in advance, because we often get lots of questions on the same topic. So it really helps, again, to make the session as useful and as efficient as possible to group similar questions together. So the cutoff for that is tomorrow lunchtime. So please, if you could get sharing those questions, and there is a form for you to do that. So we've sent the form by email. It may be that Bev will share that in here as well, potentially at the end. But just think about any questions you've got for tomorrow and get those sent in. So you probably think that contracts are boring, restrictive, yet more paperwork. And we talked about this yesterday, didn't we? About the fact that I'm called the least lawyery lawyer, and people love the fact that I'm the least lawyery lawyer. And when I worked in London, in the city, a big international law firm in the 90s, and I used to tell people outside of work that I was a lawyer, they're like, oh my God, I can't believe that. And I thought it was the biggest compliment ever. Because I had that feeling as well, that, contracts feel heavy and it's just a necessary evil that you have got to have in place. Well, I have completely changed my mind on that since I have been collecting stories from my clients and all the people that attend my events about the difference that getting straight and sorted on your essential legal protection in place. I realized how deep and how fundamental it goes. It goes really to the core of your business. So in fact, I really want you to challenge that perception of contracts and just have a different attitude, because this is what contracts actually are. They are an exchange of energy. That's what's going on at the heart of a contract. It's an exchange of energy. They are a comfort blanket, a life raft, a pep talk, and the best therapy session on boundaries, all wrapped up in a deceptively dull looking document. But this is what is going on in your contract. So I really want you to change your mindset and how you feel about your contracts, your client contracts, and in fact, any of the commercial contracts going on at the heart of your business, because they really are your best friend. When you get them right, they are your best friend, and they can make all the difference in the world. And something I just want to touch on is that I know that contracts will make a huge difference, and especially your client contract will make a huge difference to all of your businesses, especially because of the types of businesses that you have and the way that you really go deep with businesses or people and the way that you help them. You know, it's important that you get boundaries and protection in place for yourself so that you can go in and do your best work. So I know, hand on heart, that these documents will make a big difference to all of you, but there are a couple of subsets of the people here where your contracts are, you know, even more essential, because I know for some of you, not having these documents in place and not having something in place that you feel confident is managing the potential risk and protecting you from the vulnerable areas. For some of you, if you don't have that in place, it will stop you either from launching your business at all, or you might launch your business, but you will play small and you won't really grab the opportunities that come your way or really promote your business. And I've noticed over the years there are a couple of subsets of people where this is absolutely the case. And that tends to be, it could be that you are coming from a background, from an environment where there has been a lot of awareness and systems in place around risk within the business, and having very strict systems and checks and balances in place to minimize and manage that risk and those potential problems. So that would tend to be people that are coming out of a medical background, potentially out of the NHS, perhaps out of health support services, perhaps working with vulnerable people, or it could be out of a large corporate environment where there's been a lot of risks that's had to be handled. So very often, if you're coming from that environment and then setting up on your own, you're bringing with you an awareness of the potential risk. And that's not a bad thing, because that risk does exist. So it's good that you have that awareness, but because you have come from that background and you have that awareness, it really is front and center of your mind. And then the other people where this absolutely is the case and will stop you from really getting your products and services out there is just some people, and I can't be any more technical than this, but some people are just built that way, and they just have not because they've come from a particular background, but because of who they are as people, they are particularly aware of the potential risk and dangers, and it worries them and holds them back. And I have seen time and again that getting a contract in place that you know is right for your business and that you know is legally correct really sorts that out. I've gone from clients waking up in a cold sweat in the middle of the night worried about the potential risk to very confidently getting their products and services out there because they know they've got it covered. So for those of you that I know will be here in this room, you know, this is absolutely a godsend for you. A client contract does many things and helps to minimize or completely solve or get rid of a lot of the things that we've been looking at up till now that have been playing on your mind. But I would summarize what a contract does in these three areas. The first thing it does is it brings clarity. It brings clarity to the most important relationship at the heart of your business, which is the relationship between you and your clients. And when things go wrong, so often it's nothing to do with anybody wishing any harm or having any kind of malign intentions towards the other party. It very often is just a misunderstanding, a breakdown in communication. So having that contract in place in the first place means that you have clarity about that exchange that is going on between you and your clients. And in fact, because when a client signs up with you, it's a bit like the honeymoon period. You know, you're kind of finishing off each other's sentences. You can't imagine anything ever going wrong. But along the road, when you're providing services, things can get a little bit bumpy. All sorts of things can happen. And so just having the discipline to think through all of the potential areas of responsibility and what's going to happen in different situations and exactly what you're being paid and when and exactly what you're providing in return helps to make sure that if anything gets a little bit bumpy, you've got this wonderful document you can refer to. It just takes all of the drama and the emotion out of it, which means that you can get on with the stuff that you're really good at, the stuff that sets you alight, and your contract sorts out exactly what is going on and how you're going to deal with something if things go a little bit bumpy. So clarity is one of the first things. Boundaries, oh my goodness, the beautiful, beautiful boundaries that you set out in a contract makes all the difference. And a couple of the kind of main things, all sorts of boundaries will be covered off in your contract, in your client contract, but some of the main areas is your area of responsibility and your client's area of responsibility and what you're not responsible for. That's also important. And for any of you providing coaching or support of any kind in relation to people's health and wellness, having very clear boundaries around the difference between what you do and clinical medical care and traditional medical treatment, having very strong boundaries around that is incredibly important. But also boundaries about how much notice people need to give if they want to change sessions, if one-to-one sessions is part of what you do. Boundaries around how people contact you in between sessions. Boundaries around what people can and can't do with the materials and the resources you're sharing with them. So many beautiful boundaries there. And then protection, all sorts of protection again, but one of the main sorts of protection that is there in your contract is your limitation of liability. So that if things go wrong, it's set out clearly the extent of your responsibility if things go wrong because you've messed up, because we are human and sometimes we mess up. So we need to have something in there just dealing with that. And that just helps to make sure that you can sleep soundly at night. And in particular, if you're a sole trader, it helps to make sure that you are protecting your personal assets, because when you're a sole trader, there's no separation between you and the assets that you own, including your home. So also helps to make any co-owners, any partners who co-own property or assets, it helps them to sleep soundly at night as well. Now, some of those specific areas and some of the kind of concrete ways that translates itself into in your contract is having really clear policies and clear policies around refunds and cancellations, which means that as a result, you're going to get fewer spurious refund requests. And when you do get a refund request, it doesn't need to be all emotional. You can calmly point to the correct clause in your contract, but you need to make sure that you know that it's legally correct. And what is legally correct will depend on what type of product or service and also what type of client. In particular, is your client or your customer a consumer? Now, we are going to look into that a little bit more closely a little bit further on in the session. So we're not going to dive into that now, but we will look at that a bit more closely, because that's one of the really main things you need to work out, and one of the things I'm going to help you work out this evening and during the rest of the week. And also, in your contract, you're going to include protection and boundaries that are going to help to ensure that you get paid, because cash flow is so important. And it's been, economically, it's been a bit tricky over the last couple of years. It's been quite a crowded space for some products and services. And so having clarity around payment and what happens if people don't pay you on time, it's really important to ensure that if people are struggling and they've got a number of different things to pay and they need to decide the order in which they're going to make those payments, then you having a professional, relevant, legally correct contract is going to help to ensure that you are top of the list of the people who are going to get paid, and that can make all the difference in the world. So here are some of the important components of your contract. There's some homework as well. So anybody who already has got a contract in place, there is homework, and there is a list of the elements that need to be in your contract so that you can go through that list if you've got an existing contract, and that's going to help you to identify if your contract is up to scratch. And that checklist is in your workbook. So we don't have time to go through that checklist now, but it's in your workbook, and that's something you can do. And if you have any questions arising from that, then please bring those questions to the Q&A tomorrow or the Q&A on Sunday. But here are some of the kind of headline clauses that you want to have in your contract. The first is a services description. So you want to have a services description in place that is describing what you are doing. And that needs to be, when you're writing your service description, that needs to be a list of specific, measurable elements. So I want you to have in the back of your head, if things go a little bit awry and a client is calling into question whether or not I've done the things that I said that I was going to do, can I go through this list and go, yes, I've done this, yes, I've done this, tick, 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 tick. So that's what you're aiming for with your service description. So it's not like the marketing speak, it's not trying to sell your services, it's just talking about, this number of sessions of this length, these materials, this type of support by WhatsApp, whatever it might be, just a really clear list of those things. In a minute, we're going to look at where that service description might be, depending on what type of client contract document you've got in place. So we'll have a look at that in a minute. A legally correct refund policy, it needs to be legally correct, and that takes some time to work out. You need to look at what kind of products and services, and also who your customers are. Are they businesses? Are you providing business services, or are they consumers? And we're going to look at that in a minute. But it needs to be correct, because if it's not correct, it won't stand up when you need it most, and you won't get that wonderful, confident feeling and that feeling of sovereignty. And so that's really important to get right. And some things in your contract, there isn't any magic to the wording. It just needs to be clear and included, and not to be ambiguous in any way. But with your refund policy, you need to have the right words in there. Same with the limitation of liability clause. So that's the clause that's going to make sure that when things go wrong, you're only on the hook for what is reasonable in the circumstances, bearing in mind the type of products and service, and again, the type of client. And that is a technical clause, and that needs to be legally correct. Another couple of clauses that are really important to have in there is IP protection. So whenever you are giving people access to your assets, to the things that you have created, you want to be really clear around what they can do with those assets, what they can do with those resources. Are they just for their own personal use? Are they just for their internal business use? Or is it some kind of service or product, or maybe a certification where they're able to share those materials with their own clients? So you need to have clarity around that. And then one of the things that's important to have there, and I think it's appropriate to have in any contract, and that is a clause allowing you to charge interest on late payments. Now, in many circumstances, you won't end up enforcing that, but it's still good to have in there, because if someone is delaying paying you, it just helps to concentrate their mind, and again helps to push you to the top of the list of the people that are going to pay if you can calmly and without emotion mention the fact that you've got a clause allowing you to charge interest on late payments. That will help to encourage them to pay quickly and to pay on time. So the next thing that we're going to look at, quick slurp of tea, is how many different contracts do you need to have in your business? And in my experience, many of our businesses have a number of different products and services going on. Now, I know we've got some people here who are at the very start of the journey, and maybe even just working up to launching your first product or service. So it may be that right now, or for the next thing that you plan, it's just going to be one thing. For example, one-to-one support of some kind for a business or an individual. But very often, even if you start with one, in a relatively short period of time, you'll be adding other types of products and services into the mix. So that is my experience, is often you'll start with one, but you'll add more into the mix. And for those of you that have been going for some time, I know, because I've looked at the post where you've shared all the different things that you've got going on, I know some of you already have a number of different types of products and services going on. So it's not the case that you definitely need a different type of contract, a different type of contractual document for each of your products and services. However, you do need a different type of contract for each type of product and service you have going on. So let me explain a little bit more what I mean by that. So the two main format of contractual documents, and they're both contracts, they just have different formats, is something I'm going to call an individual agreement and something I'm going to call tick box terms and conditions. Okay, so an individual agreement and tick box terms and conditions. So, and that's the second one there. I know it says terms and conditions for online sign up, but I think tick box terms and conditions is a more helpful way to think of it. So the individual agreement is the document that you would think, the type of document that you would think of when you think about contracts traditionally. What do they look like? Well, they have got a reference at the start and include the names and addresses of the parties. There, somewhere in the document, it will be set out what you're going to do. Often that will be in a service description, which is likely going to be at the end, but actually it could be a front sheet. So somewhere it will set out exactly what you're going to do for that person or that company. And there will be a place for the parties to sign. Okay, now that signature could be printing it off, signing, scanning it back. It could be electronic signature. In some instances, you could send it out with your signature on and people would email back confirming they agree to it. But regardless, that's the format of it. It's got the names and addresses on there. You create a new version for each person that signs up. It may be the main body stays the same, but you're creating a new version, adding in names and addresses, a place for them to sign. Now that kind of document works well for higher priced products and services. It's not a case that that's the sort that you need for one-to-one services. It's not like that. It's more about higher priced products and services, and the situation often is that there will be either an exchange of emails leading to a call, a discovery call maybe of some kind. As a result, someone decides they're going to sign up for your products and services. You create a new version of your contract with their details on, you send it out to them. they sign or confirm that they agree to it, and then you start working together, okay? So that's when you would use an individual agreement. So it's for higher priced products and services where you don't have a sign-up page. People aren't going to be landing on it and an online sign-up page at any time of day or night and just signing up for your products and services. You're going to know that they're signing up for your services, and you send them out a contract. In terms of price point, there's not a hard and fast rule, but just as a kind of artificial way to start thinking about it, you know, if it's £1,000 or thereabouts or more, you might well think an individual agreement is appropriate. When there's a higher investment, there's just a certain kind of respect that's involved in creating an individual contract for that person. And one of the good aspects of it is they're more likely to read it when it's got their name on it and it's been created specially for them. Okay, so that's the individual agreement. Now, it might be for a one-to-one program, one-to-one support of some kind, but it could be a group situation. It could be an expensive, you know, mastermind, for example, which can be tens of thousands of pounds, or it could be a retreat. I know some of you run retreats, so a retreat typically would be that kind of individual agreement because it's that higher price, even though there will be several people at the retreat, it's not one-to-one. So it's all about the kind of level of investment and the way people sign up. So for your higher priced products and services, you'll likely want an individual agreement for those types of services. But you might have a number of those types of services. You might have a number of one-to-one programs and a retreat and a mastermind, for example, and they maybe would have the same kind of document. Compared to the second type of document, the tick box terms and conditions. Now, we're all used to those kinds of that kind of contractual document. When we're buying things online, maybe it's a course, maybe we're just ordering something for the home, or you know, some kind of goods online, and we land on a page and we fill in a form and we confirm that we want to buy something, and there will always be a reference somewhere to the terms and conditions. And my preference is there's a box that people tick confirming they've read, understood and agreed to your terms and conditions. It will link through to the terms and conditions. Let's be honest, do we ever read those terms and conditions unless something goes wrong? No, in many instances we don't. But regardless, they will apply to that arrangement for whatever we're buying from that supplier. Tick box terms and conditions, and they're different because although it will contain the same sort of protection as that and the same sorts of clauses that are in the individual agreement, you're not creating a new version for every person that signs up for your products and services. You have those standard tick box terms and conditions, and they apply to everybody who's signing up to what it is. The details of what they're signing up for will be on the sales page, typically, so it'll be a sales page. So that works for lower priced products and services, where people often, you've got an online sign up page and people can land on that page any time of day or night, sign up for your products and services, agree to your terms and conditions. So very often you'll need an individual agreement for your higher priced products and services, and then tick box terms and conditions for your lower priced products and services. Now, if you have any kind of membership, any kind of auto-renewing, ongoing subscription type of service, so I have a legal hub, for example, where people often sign up for that month to month. For that kind of situation, I recommend that you have separate terms and conditions for that kind of product or service, because there can be quite a lot of hassle around that auto-renewal. So rather than having it all bunched together with terms and conditions for other types of services, I think it's good to have absolute clarity on membership and subscription. So I recommend for that type of product and service, you have a different type of document. And then finally, I know that there are many of you here, which is very typical of my clients generally, who, as well as helping people directly that you're going to be helping, that you also provide your products and services through some kind of organization. So it could be a large corporate, it could be a charity, It could be some kind of educational establishment, a university or college. It could be a trust. Any of those kind of situations, if you're providing your services through an organisation like that, then you'll need a fourth document. That would need another type of document. I've put for corporate clients there. It might not be a corporate. It could be a charity. It could be an educational establishment. It's where you're providing your services through an organisation, whether you're going in and running training sessions for groups, or you're going in and you're providing your services to individuals within that organisation, but you're being paid by the organisation. That's a different type of contract. So that is, we're going to move on to how to work out if you supply to consumers or not. Now, this is the stage, everybody, can I just say, this is the stage where it's been nice and steady up till now. We've been talking about all the wonderful things that your contract can do, but it's at this stage where we've looked at the sorts of main clauses to include. Then we've looked at the different formats and how many different contracts you might need to have going on. And now we're looking at whether you supply to consumers or not. And this is the stage where there's a lot of information coming thick and fast. So, you know, at the start, I said that there's a stage where everybody starts to go, oh my gosh, this is a lot. This is that stage. So I just want to say, trust the process. We're going to be revisiting these ideas. We're going to be going over this again. You've got an opportunity to ask questions. You can revisit this training. We're going to be filling in a table in just a moment, so don't panic, okay? Well, and we're coming to the end as well. So one of the things that you really need to work out, so you need to work out what type of document you need for each of your products and services, in as much as, is it higher priced and therefore it's going to be an agreement, or is it lower priced and an online sign-up page, and so it's going to be tick box terms and conditions. So you need to work that out for each of your products and services. But you also need to work out, is my client for this product or service a consumer? And it's important that you get clarity on this, because if you supply to consumers, then there is a load of consumer protection legislation, and it's really important that your contract complies with that legislation, because if it doesn't comply with that legislation, then your contract will not stand up when you need it most. And let me give you a really tangible example of this. And I'm going to mention Kate Waters here, because I know Kate's already submitted a question for the Q&A tomorrow about this, so I thought I might as well deal with it now while we're looking at this. There are two levels to kind of what consumer protection requires of you. The first is, it means that your clients have certain rights. The second is, you have an obligation to let your client know about those rights in a written contract. And one of the really, there are different things that you will need to weave into your contract, and also you need to write it in a certain way if your clients or your customers are consumers. But one of the main things is the 14-day cooling off period. Now, if your clients are consumers, you need to let them know about the 14-day cooling off period. And if they're entitled to a cooling off period, and you haven't told them about it, then instead of 14 days to change their mind and ask for a refund, they get a whole year. So you can see how important it is. It's not something to stick your head in the sand about. It's something to understand what the situation is and cover it off. And the thing to say here is, there are certain situations where a consumer loses the right to the cooling off period, but that will only apply, those exemptions will only apply if you've got the right wording in your contract. So if you don't have the right wording in your contract, even if they wouldn't be allowed to a cooling off period normally, if you haven't got the right wording in there, they've still got that right to a cooling off period. So it's something absolutely that you should get right. And Kate's question, and we'll be delving more into this tomorrow, I'm absolutely sure, because we always get questions on this topic. But what Kate's question was, the 14 days, where does that start from? So the 14 days starts from the point where they agree to your contract, Kate. Okay, so let's just rewind a little moment and just look at how you work out if your client is a consumer or not. The first thing to say is, if your client is a limited company, they cannot be a consumer. So if they're a limited company, they are not a consumer. If they're not a limited company and they are signing up for your products and services for reasons that are wholly or mainly outside of their business, trade, craft, or profession, then they will be a consumer. Now, that's quite a kind of wide, vague description. So let me give you some kind of concrete examples. If they're a limited company, they can't be a consumer. As outside of that, if they sign up for your products and services, and your products and services help them in relation to their business, for sure, but also help them in relation to their life in general, then they are very likely to be a consumer. So anything to do with life, health, wellness, success, coaching, anything of that nature, your client is very likely a consumer. Where people get a little bit confused is if you market your products and services specifically to business owners, for example, female business owners in their 40s, but the way in which your services help them is in a holistic way that will support them in their business or their career or the profession, but it will also help them find balance and success and confidence in their life in general. Even though you're marketing to business owners, they will be consumers, and you need to make sure that your contract complies with consumer protection. So, as always, we have been fitting a lot into this session, and I'm aware of the fact that we are coming up to 8 o'clock. So before we finish, can you just take a couple of minutes to look at the table on page 4 of the workbook? And on the left-hand side, we've got that column, which is product or service. So those of you that were here yesterday, you hopefully set out each of your products and services in that column. So a row for each product or service. If you weren't here yesterday, that won't take you long to do. So you need to set out each of your products and services, either existing ones already or ones that you're planning at some point in the next 12 months. And then I want you to go along and for each one, look at the second column and think, is it an individual agreement because it's a higher price product or service? Or is it tick box terms and conditions because it's lower price and they're going to be landing on an online sales page any time of day or night and you want them to be able to buy? So for each of your products and services, identify that. And then in the final column, for each of your products and services, identify, are they consumers or are they non-consumers and you're providing them with business services? So an example of where somebody is not a limited company and you're providing with them with services, an example of someone that would not be a consumer in that situation is if it were a sole trader, so not a limited company, and the way in which you help them is purely business related. So it's in relation to their marketing or their systems or team building within the business or setting up their meta ads, for example. So those kinds of things where it's nothing to do with their life in general, it's specific to do with your business, then they would not be consumers either, even though they're not a limited company. So look, I know we've covered off a lot now. We're coming to up to 8 o'clock. My priority for you now is just to fill in that first page of the table on page 4 and just get that done. Now, it shouldn't take very long. But for some of you, you might still be working that through. And if you've got any questions around it and how that relates to your business, then by all means, put your question in the Q&A box and I will answer it this evening, and you can catch up. If you've got to go, you can catch up with the recording, or submit it as a question for our Q&A tomorrow and I will answer it then. And again, even if you can't make it live tomorrow, you can catch up with the recording. So lots of opportunity to get my input on your specific business in relation to this. I know we've covered a lot. Don't panic. We absolutely have got time for this to really kind of soak in and to get understanding about it. But in relation to the contractual elements we're going to cover, you know, you've got all of that information now, so it's just time for you to work through it and work how it relates to your business. So before we go on to the questions, and one of the questions that I'm preempting because it's already come up a couple of times recently with clients of mine, but also a question we had yesterday: is it safe to use AI to draft my contracts? We'll look at that in a minute as part of these questions. But just to mention, if you have an existing contract and you want to have a think about whether it covers off some of these elements, then we've got that checklist for you to go through in your own time, which is on page 11. So if you've got an existing contract and you are hoping, after all that we've gone through, that actually it is fit for purpose, then go through that checklist, and that's going to help you work out if it includes some of those things that we've talked about this evening. And just a reminder that we've got the funnest legal Q&A you will ever be invited to, happening tomorrow at 7 o'clock. All the answers to your legal questions, and just a reminder to submit your questions in advance. And a reminder about our competitions that we've got going on. So we've got a competition going on for interacting in the Facebook group, and the prize for that is a non-legal prize. It's a gift voucher of your choice. You can choose from John Lewis, Marks and Spencer's, or Amazon. And then we've got our competition of winning £750 of legal support, a place on our legal lifesaver sprint for us to hold your hand in getting all of your essential legal documents in place, and a one-to-one contract review with me. So the information about how to enter that competition with the legal prize, all of that information is in the hub. You can click through to the competition page, but just to remind you, it's all about sharing your takeaways from these sessions. So after each session, you can share your takeaways on the correct Facebook post. And on the competition page, there is a link to the correct Facebook post, and you go there and share your biggest takeaway. And you can go back and do previous workshops if you haven't done that yet. So you can go back and share your biggest takeaway from workshop 1 if you've been catching up with that today. You don't have to do it on the day. And every time you do one of these things, you take one of these actions, you get another entry into the competition, if you like. So what you can also do is share this event and talk about it on Instagram or Facebook, either your stories or on your timeline or on the Instagram grid. Tag us in, and that will get you another entry as well. You know, it might be a selfie with you working through the workbook, or sharing one of your big takeaways again. So every time you take an action, you get an entry into the competition, and we will announce the winner on Sunday. And as I said yesterday, this is not such a big event that you haven't got a chance of winning. You know, if you take part and you join in, you are in with a decent chance of winning. So it is definitely worth having a go. And so tomorrow is our legal Q&A at 7 o'clock. And then we've got our third teaching session, which is all about your website and your online spaces and making sure they're legally compliant. So all of the GDPR and personal data type stuff, we're going to be dealing with that on Friday. And that's at the slightly earlier time of 6 o'clock, because we know you will have lives to lead and things to do on a Friday. So we make that Friday session a little bit earlier. Okay, it's now just after 8 o'clock. Bev, I don't know if you've yet shared the the freebie, but maybe you could, oh, there you go. Bev has already done that, did that very promptly at 8 o'clock, which is amazing. I'm now going to go back and look at the comments, look at the questions, talk about, is it okay to get ChatGPT to draft your contract or not? But I know that some of you have got to slip off now, and that's absolutely fine. Please remember, don't panic, don't feel overwhelmed. There is plenty of time for this to settle in, to percolate, to get my input. But hopefully you've learned a lot this evening and you're not feeling too overwhelmed. So let's have a look. Yael said, I loved yesterday's legal bonus. That makes me very, very happy. Sammy said, will tomorrow's Q&A be recorded as unable to attend tomorrow? Absolutely, Sammy, it will be. The recording will be in the hub, as with all the other sessions. Helen said, I love this, especially an exchange of energy in a comfort blanket. What a fabulous way to look at it. Genuinely, Helen and everyone else, even when I go through the list of all the things that your contract does, I feel my nervous system settle as I talk about all of the things that it does. You know, and that is the effect that it has on you. And that's kind of the change in energy. Even as I just talk about the clarity and the boundaries and the protection and taking the emotion out of things, it just feels so good, you know, and that's what your contract is about. It's not the paperwork. It's not a necessary evil. It's a wonderful feeling. Mafalda said, thank you for everything tonight. Lee said, thank you, that's brilliant. Amy said, another very helpful session. Arhan said, excellent topic. Tracy said, what about LinkedIn? Very good question, Tracy. And honestly, you're the only person that has ever mentioned this. It's a really good point. If I'm honest, I am not very active on LinkedIn, and I know I should be. So that's no excuse. But Tracy, if you want to share it on LinkedIn, I have a page on LinkedIn. If you want to share it on LinkedIn and finding a way of letting us know, then absolutely sharing on LinkedIn also counts. It's a really, really good point. Sammy said, thank you, I've got to go now. Great session, Tash. Susanna said, this is so helpful and clear. Susanna, you don't know how much that means to me, because as I said at the start, I get nervous about this session because there is so much to share and I know it can feel overwhelming. So that makes me very, very happy. Louise said, thank you, I really enjoyed the session. Alistair said, thank you, that disclaimer bonus is great. Yes, Amy, we will sort that out for you. Debbie said, thank you, fab session. Min said this was, hey Min, nice to see you. I've now realised it's Min who I spoke to last week. This was so informative and equally reassuring. Thank you for sharing your knowledge and insights with us here. Brilliant, Min, I'm so glad. Colleen said, your pace is very helpful for me to be able to follow. Good, that makes me happy. Susanna said, I love the way of looking at problems between client and service provider as being often rooted in misunderstanding. So true. We can just slip up because we and they have made assumptions about things without questioning it. Absolutely, Susanna. And you know, the process of getting your contract in place makes you have the discipline of thinking through different eventualities and different things that might happen right at the start. So you head them off at the pass. You head that drama and emotion and hassle off at the pass before it arises. It's a wonderful discipline to go through to do that when you're putting something new out there into the world. Savvy said, excellent session. I have lots to digest and decide. You absolutely do, Savvy. Lorna said, very well explained. Thank you. You're so welcome. Amy said, great session and not too much info. Yay, Amy, good, I'm glad. Vasi said, thank you, so well explained. Rian said, thank you, Tash, this has been another great session, so clear. Thank you so much, everybody. I really appreciate you sharing this because, you know, there is a lot. I know there is a lot that we go through. So I am now going to look at the questions And I am also going to quickly deal with the point, is it safe to use AI to draft my contract? Let me tell you, I am not anti-AI. I think that AI can be a great tool for our businesses. I think if you have a business in this day and age, then it's smart to understand how you can use AI in your business. But I think you have to use AI with selectively and with discernment and in the way that is best for your business. So for us, we use AI to help us create content for marketing purposes. So we use AI to help us create blogs, informative posts, social media, to come up with social media campaigns and that sort of thing. However, we use it very selectively. So if it's creating anything on a legal topic for our marketing, we make sure it is only basing that information on what I have uploaded into it. So based on my many, many years of legal training and legal knowledge, because I don't want it just grabbing bits and pieces randomly that have been put out there about legal stuff, because so much of it is wrong. So anything that I create that has anything to do with legal stuff, then is only based on my existing knowledge and my existing resources. And in terms of anything that is for us to share in relation to our brand, in relation to any emails or again articles or social media posts or anything like that, Bev and I have spent hours and hours training ChatGPT in my voice. So we have uploaded hours and hours and hours of sessions like this and of me talking about all the different legal topics, and really trained it to sound like me. So we use it very selectively and with an awful lot of discernment, and that is a great tool for our business. So I'm not saying don't use AI at all. I'm saying, of course, use AI in your businesses, but use it in a smart way and use it selectively. And one way in which I cannot recommend that you use AI is to create legal documents. And there are some really clear stats around this, but there's also very specific experience of mine around this as well. And so there was a Stanford University study in 2024, and it found that ChatGPT gave wrong answers to legal questions 58% of the time, and with some models, it gave wrong answers up to 88% of the time. And this, by the way, was just in relation to specific legal questions, not drafting whole contracts that need to be legally correct for your business, your clients, your types of products and services, and the legislation where you're based. So, a lot of the time it's wrong, even with small one-off questions, let alone drafting a whole contract. The other statistic, which I think is really quite scary, so there are specific legal resources designed for qualified lawyers and law firms, so that when they're doing legal research, when they're drafting a type of document, there are resources to help those people. I am signed up, for example, to Lexis Plus. Those tools are designed specifically for lawyers and cost hundreds, if not thousands of pounds per user, depending on what access you get. And Lexis Plus has an AI function, which I have played with And all of the other legal resources have those sorts of services as well. So like Westlaw AI, even those AI elements of specific legal resources designed for lawyers that have banks and banks of lawyers doing nothing but creating content for them. And they have huge bank of correct legal resources to mine for whatever the answers they're producing, produce errors. Even those resources produce errors in up to 33% of responses. So even the specific legal AI resources for lawyers and law firms get it wrong a lot of the time. And I tested that when I was playing with Lexis Plus AI, and I tested it by saying, can you draft me a contract for this situation, blah, 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 blah. And it came up with the contract, and I looked through it, and even though this was created by a purely legal resource, there is no way that I would have used that contract. It just didn't hold together properly, and it had huge gaps in it. And the thing is, AI does not give legal advice. Essentially, what it does at the heart of itself is it predicts text. So in many instances, it will generate clauses that sound legal, but they are not clauses that will stand up when you need to rely on them. They're not enforceable under English law or whatever law applies to your contracts. And the first time I came across this was when a client of mine, who is a really big name, you know, a famous name in the world of wellness, and I'd acted for her for a number of years, and she went quiet for a little bit, and then she asked me to review a contract for her that I hadn't drafted, and she said that it had come from someone else. And I'm not, you know, I'm not narrow-minded. You know, sometimes people might try another lawyer. It was interesting. So she said, I've had this contract drafted. I'd be really grateful if you could have a look at it and see if it's fit for purpose. And I had never seen a contract like it, because just this point that I've mentioned, it gave the appearance of being a properly drafted legal contract. So at the very first view, it seemed to make sense. It seemed to have the right sorts of things in there. But when I looked at the major clauses in it, it was like you couldn't get to the heart of what it was actually saying. It was all smoke and mirrors, and it had the appearance of a correct legal clause, but you really couldn't bottom it out and work out what it was doing. And it was absolutely bonkers, that contract. I had never seen anything like it, and I was completely perplexed by it. It's like, it appears like it's dressed up as though it's correct, but it just isn't. You can't get to the heart of what's going on. That would offer no protection in a court of law. And I even said to her, I went back and said, this is really weird. And she fessed up to me, and it had been something that had been drafted, I don't know by which kind of AI service, but it had been drafted by AI, and it made so much sense to me when I heard that. I was like, yeah, this has been drafted not by a lawyer, not by anyone who knows what they're talking about. And the thing that's really dangerous about it, though, is that when a document's been drafted by someone who isn't a lawyer and doesn't know what they're talking about, and they've just pulled bits and pieces together here and there, you know, if you had done that, you would have a real worry about it and just think, well, I know that I've just pulled this together myself. It's likely not right. To me, that's less dangerous than the situation where you've asked, you know, you're all intelligent business owners, and you've asked some sensible questions and inputted as much sensible information as you can to an AI platform and asked it to produce a contract. And you know what it's like, you know, AI, ChatGPT, so sycophantic, it's such an echo chamber of ourselves. And I know that they're starting to address that now, but you can just imagine, you know, putting in all of the instructions and it coming back and saying, you're so right to want to include all of these things in your contract, and here is the contract that I have drafted for you. And it does it with such confidence, doesn't it? That I know it would be so easy to look at that a bit like the contract I review for my clients and just think, oh, that sounds really good, you know, and it's pretty long and it sounds really legal. And unless you've got the specific legal knowledge to know that the limitation of liability clause is wrong, or what it's got in for consumer protection legislation, it is not right, unless you've got that legal knowledge to challenge it, then I think it's quite dangerous the way that AI presents the things that it creates as being correct. And I think it's so important that where it's output that matters, and my goodness, your client contract, your legal documents really matter. It's so important that they are reviewed by a human who knows what they're talking about, who knows about that topic. So for those reasons, much as I love AI in my business when it's used selectively, I do not recommend that you use AI to create contracts. And I certainly do not use and did not subscribe to the AI service with Lexis Plus because I was not happy with what was produced. Now, who knows, maybe in 5 or 8 years' time, who knows, maybe that position has changed, but that is definitely the situation right now. So I just felt like it was really important to talk about that, because I imagine that a lot of people are starting to think, oh, I'll just get AI to do it. And it's just not safe to do so. Okay, I am now going to go into the question box and have a look at your questions. And Susanna said, yeah, I find that concerning. Tracy mentioned, of course, AI is bad for the environment as well. Lee said, selectively and with discernment, great advice. Yeah, I'm definitely, look, I'm not a Luddite about AI, I promise you I'm not, but I just know that we are not at a stage where it's safe to use AI to create legal documents. Okay, so now, if any of these questions are very long questions, I can feel that my voice is getting a bit croaky, and it may be that some of them we talk about tomorrow if there's any long questions. And if you can't make it tomorrow, you will be able to catch up with the recording, but I can just feel my voice is getting a bit croaky. Let's have a look. Michaela said, I'm thinking of running online group hypnotherapy sessions and programs and online courses. Are there any legal bits that need to be known? Well, hopefully, Michaela, with the things that we've covered off in this session, we've answered a lot of that, because actually, you know, all of the points that I've mentioned around making sure that you have specific measurable things set out somewhere as the description of what you're providing, that applies equally to all kinds of products and services. Those boundaries that I mentioned apply to all types of products and services, and really, very importantly, to hypnotherapy. So those boundaries are very, very important around the difference between what you do and traditional medical treatment, for example. So definitely having those boundaries in place. And as we said, you know, it's very much the case that these would be consumers. I can't think why they wouldn't be consumers. So you need to make sure that you comply with consumer protection legislation. That's very important. And then you just need to decide what type of document. Is it going to be, is it higher priced products and services? In which case you would go for that agreement, or is it lower price one-off sessions, in which case you want tick box terms and conditions for those. How long do we need to keep records for? So there is definite guidance about how long you keep records for kind of financial purposes. In my contracts, I always put that keep records for 6 years after someone stops being your client. So that's what I typically advise. Tracy said, what advice do you have around having more than one contract? So we've covered that, Tracy, obviously. So if your client is someone under the age of 13, then you definitely need their parent to enter into the contract with you. And I would say that if it's someone under the age of 18, it's a good idea to have the parent entering into contract with you if it's services to do with their wellness and their well-being. And you've mentioned organisations here. So Tracy, if you are then separately providing your services via an organisation, as we kind of saw towards the end of the session, then you would make sure that you have an agreement with the organisation, which would be separate, would be a different type of contract, the contract you would have when you're being paid directly by the parent. So that would be a different type of contract. Okay, so Arhan said, what is the difference between disclaimer and terms and conditions? If you have a pre-recorded video series that is on an educational topic of interest at a low investment point, with no refunds possible when they purchase, do you need terms and conditions, or will a disclaimer be enough? So I would say that, so a disclaimer is something that it's an element of a contract typically, or it could just be something that goes alongside information. So information that you're making available on your website, for example, or information that you're making available in an article where you want to say the disclaimer would be, this is just for general information purposes, this is not specific advice for your situation. I would say that whenever you are selling something, a disclaimer is not enough, and that you want to have terms and conditions of sale. Now, you've mentioned a pre-recorded video series on an educational topic of interest at a low investment point. So, and with no refunds possible. So you can't say no refunds possible, because that would just be unreasonable to just say outright, no refunds possible. So then we need to kind of look into a little bit, are your clients consumers? So if your clients are consumers and they are buying a product which is a digital product, a purely digital product, so what I mean by that, Arhan, is it's pre-recorded videos and that is all they get, and maybe some PDFs to go with it. If there is no element of extra support alongside it, so no Q&As, no support in a Facebook group, no live sessions, and it's purely digital, actually, in that situation, you can say no refunds unless it's a faulty product. However, so that is one of the kind of carve-outs from consumer protection law, because it's a purely digital product. However, that exception to the cooling off period only applies if you have explained that that is what will happen when they buy this product. So you still have to have wording in letting them know that the cooling off period doesn't apply, and it has to be the right wording. So you definitely can't do without the terms and conditions. So if you do without the terms and conditions covering all of that off, then they will still have the right to a refund, even though it's a purely digital product. So definitely terms and conditions, Arhan. Okay, we've got something from an anonymous person about VIP. So the VIP, you get a number of extra things with the VIP. You can still be a VIP. You can still sign up for that. It's £30. You get a session all about intellectual property where we go through your intellectual property. That's happening this weekend on Saturday. And then there's just a dedicated VIP Q&A as well. You get to keep the recordings of all of these sessions for the next year, so you have much longer to consume everything. And you also get some template documents from me, including best practice AI wording to include in your client contracts, and also diversity and inclusion policy and environmental policy. So there's a load of extra stuff in there for just £30. So it is a really good deal. Helen, I'm curious, if I decide to do group coaching, would that typically need tip box terms and conditions or individual contracts? Okay, Helen, so that will depend. It doesn't depend on whether it's group or individual. It depends on the level of investment. So if the group coaching is, you know, £800 or under, I would say tick box terms and conditions. If it's over that, because group coaching sometimes can be, you know, a higher price point. So if it's over that, you will start to think about an individual agreement. And if it's several £1,000s, you definitely think about an individual agreement. I would say group coaching in many instances would be tick box terms and conditions, but it does depend on the level of investment and how people sign up for it. Okay, from Anonymous, is this correct? Wellness, health, fitness equals consumer protection. Yeah, so typically wellness, health, fitness equals you need a contract which complies with consumer legislation. I would say that don't forget, however, if you're helping people in those areas through an organization, so maybe they're employees at a company and a company is paying for you to help individuals within their organization, then even though those individuals are consumers, because your contract is with the organization, then in that situation it's not a consumer contract. I would also add to that wellness, health, fitness, general kind of success coaching, life coaching, coaching around confidence and general performance in life and business. In those situations, typically your clients will be consumers. Anonymous attendee, limited company, sole trader, business repeated help, e.g. setting up ads. So if you are helping a business set up their meta ads and that's how you help them, then that business will not be a consumer. So you don't need a contract that complies with consumer protection legislation. You still need a contract, but it doesn't have to be one that meets the requirements of consumer protection legislation. Okay, Michaela, I'm just looking at your question and it's a little bit long, so I am going to read it, but I just need to take a moment. And then if appropriate, I'll answer it today, or otherwise it might be something that we answer tomorrow. Okay, let me just bear with me a second, everybody. Michaela, I'm not going to answer that today because it's very, very specific about your situation. So I feel at this point in the evening to take a lot of time about your specific contract for your situation, it probably isn't a good use of time. So forgive me for that. But what I would say is that, you know, you can have terms and conditions that people agree to on a Google form. So that is a way that it can work, but it still needs to have terms and conditions that cover all of those elements that I've talked about. Okay, Arhan said, what if you speak at a summit or conference that has over £1,000? Is it contract 1 and 4? And if people, okay, so if you were to speak at a summit or a conference, then I would think that yes, that would be an agreement rather than tick box terms and conditions. And yes, it would be a situation where you are dealing with a corporate, so it would be that type of contract. So yes, I think you're right there, Arhan. Okay, Arhan, what happens if you realise that something was needed in your terms and conditions after the event that wasn't in place? Well, if it's not in your terms and conditions and you realise afterwards that it needed to be in place, that won't apply to the situation with that organisation or whoever it is that you've entered into a contract with. So if you wanted it to apply, you would need to get their specific consent that it would apply. But if you were entering into another arrangement with the same party, then you could negotiate a new contract. But for that contract that you've already entered into, those terms and conditions wouldn't apply unless you get their specific consent to it. Okay, Yasko said, would group coaching be terms and conditions rather than individual, or does that depend on the price range? So yeah, same point that was raised earlier. It depends on the price point. It's not about group coaching versus individual coaching. It's about the price point and how they sign up. Michaela wanted some more information about the 14-day cooling off period. I will talk about this, Michaela. I think we'll also be talking a bit about it again tomorrow. So the basic position is, if your client is a consumer and they sign up for your products and services online, so it's not the same if they come to visit you in a shop, for example, or you have an office, you have premises where they come and visit you. It's not the same situation. But if they come and see you, if they sign up for your products and services online, then when they sign up, they have what is called a 14-day cooling off period. And that means from the point when they sign up to your products and services, so they enter into the contract with you, they have 14 days during which they can change their mind and say, do you know what, I've changed my mind, I don't want to go ahead with this anymore, and you have to give them a refund. Now, there are lots of different situations that might happen where it's an exception to the cooling off period. So if they start to use your products and services within that 14-day cooling off period, then they lose the right to get a full refund, and they have to pay for some of your products and services that they've used in the 14-day cooling off period, but only if you have the right wording in your contract. So that's an example of, that then becomes an exception to them being entitled to a full refund, but only if you've got the right wording in your contract, which is why it's so important that you cover it off properly. And if you don't cover it off, they have up to a whole year to change their mind. So it really is an important one. It's a really complicated area, Michaela, and actually what we ended up doing with our contracts, our template contracts, so we wanted to put our clients in the strongest possible position in relation to the cooling off period. So we had a barrister who sits as a judge and makes these decisions to go through all of our contracts and make the wording, include wording to put our clients in as strong a position as possible, because it really is, very technical and very specific. And one of the problems is the way that the law gets fleshed out in these topics is by having decisions made of the court. But because a lot of the amounts that we're talking about, relatively speaking, are quite low amounts, most of these situations don't end up in court. Luckily, we had this barrister, we invested a lot in this barrister to review our contracts and really tighten them up on behalf of our clients, because he sits as a judge and he makes these decisions, so he knows the sorts of things that get applied by the courts. But it is a technical area. Okay, Sally said, if I run an in-person workshop, would that be tick box terms and conditions rather than an individual agreement? It depends on the, if they're signing up for the workshop in advance, Sally, then it would typically be tick box terms and conditions if the amount they're paying for the workshop is under £1,000 and there's just a sign-up page for it, which I imagine there would be for the sort of thing you were talking about. Then yeah, it would be tick box terms and conditions. If I'm a therapist who provides clinical supervision for other therapists, does the supervisee count as a consumer? I would think not, Susanna. If there are therapists that, you know, that's their profession, that's their business, then they wouldn't be a consumer because you're helping them purely in relation to their business. So no. I mean, I hear what you're saying. It's a great source of support, which does me good holistically, but actually it's all about supervising, you know, the work that they're carrying out. So they wouldn't be a consumer. Yasko asked, what provision do we need in terms of using AI as part of your work? I'm going to cover that as part of tomorrow's session, Yasko, because that's a whole other topic really. But what I would say is, I can't remember if you're a VIP or not, but if you're a VIP, then one of the things that is included is best practice wording to include in your client contracts if you use AI as part of your services. So if you're interested in looking at what that wording looks like, that's part of the VIP package. But I will talk about that a little bit more tomorrow. So Bev, if you could make a note of that, that would be great. Okay, we are getting there, everybody. We are getting there. Okay. Okay, Jim, I deliver well-being services to non-paying private individuals referred from the NHS, local authority via or self-referred via a CIC, which pays me as a freelance provider. Should there be a service agreement between myself and the end users? So in that situation, Jim, what I would say is the main contract is between you and whoever is referring your the end users to you. So it's between you and the NHS, the local authority, or the CIC who pay for you. So that's where the main contract is. You might decide that you want to have some document in place which is managing expectations around your role and giving the very kind of practical support around or practical guidance around what they need to do if they want to change a session with you, whether they can or not change a session with you. So if you're helping people on an individual basis, it might be good to have a document in place that they see and they sign up to, which has that kind of information. Now, it's not strictly a contract, but that could be helpful to have in addition to the contract, which is actually with the referrer. To you, Dehansa, I haven't been able to find much online about standard refund agreement for coaches. I don't have it in my individual contract, and I've had to give full refunds twice as a result. Yeah, so that is a very typical situation to you. And what I would recommend to you is that you use if you're not in a position, so many small business owners aren't in a position to pay for someone to draft a bespoke document for you. I recommend that you use a template contract that is starting off from the right position, that you know is legally correct, rather than trying to draft it yourself, because it's really quite a technical thing to do. And I do recommend that you use a template contract for your kind of business and for your kind of client, rather than trying to draft it yourself, because it is, you know, it's a difficult and it's an important area. And the 14-day cooling off period is slightly different to a refund clause. Obviously, there are similarities, but the 14-day cooling off period is for consumers. It means they can change their mind within 14 days. After that point in time, you are able to state that people can't change their mind and they're not entitled to a refund as long as you are able to make the case that they're signing up for something as a whole, and it's a whole program they're signing up to. But this is exactly the sort of thing that we had the barrister to advise us on in terms of our contracts, because we wanted to be able to include the sorts of things for our clients that puts them in a stronger position as possible to say that after the cooling off period, there are no refunds allowed. But you do have to be careful, and you do have to make sure that you're not saying no refunds ever, because of course if you mess up or if you stop providing the services, maybe you become very ill, maybe you decide to just go on a world trip to do something completely different, then of course you've got to give a partial refund for services they've paid for in advance and haven't received. So it's not quite as simple as just a blanket no refund policy after the cooling off period. You still need to draft that clause very carefully. Okay, and Daphne said, if we work with clients outside the UK, but we are based in the UK, which law applies, UK or other law? Really interesting point, Daphne. And I will be talking about this tomorrow again, I'm sure, because we always get questions around this. But interestingly, it's up to you to decide which law applies to your contracts. If you're providing services, then you can decide which law applies to your contracts. Now, if you're based in the UK, typically you would say that English and Welsh law applies to your contracts, or you might say that Scottish law applies to your contracts, and that would be the same no matter where your clients are based. However, I also have clients that have been based in Bali, for example, or in Canada, who've decided that they want English law to apply to their contracts. And English law works very well in an international setting. So even if you're not based in the UK and you want English law to apply to your contracts, then that's something that you can do. But typically, if you're based in the UK, you would have it so that English law or English and Welsh law or Scottish law applies to your contracts, and that works really well for an international context. It works no matter where your clients are based. It's an interesting question. I'm sure I'll be talking about that again tomorrow. Okay, it is 8:45, everybody. So we have been going on for a long time, but I will be answering more questions tomorrow. Thank you so much for turning up this evening and asking so many brilliant questions and for staying so long. I really appreciate you, and I will see a lot of you tomorrow at our Q&A session. Don't forget to submit your questions for tomorrow's session, and I hope you've all found that useful. Thanks, everybody. See you tomorrow.